All right, we are now live.
Tell the chief, the panel, chief arbitrator.
Thank you.
Anybody else hear the background noise?
Yeah, I think she just muted herself.
Okay.
So it looks like we're live. Thanks everyone for joining us today on the Blakley Butler Moot Court Finals. Just to give a quick introduction, today it's teams 6 versus 5 and team 6 for the petitioner. It's Che Boner Walton versus Katie Resnick. And on team 5, it's Michael Moore and Samuel Hooper for the respondent. So go ahead and get started once you're ready.
May it please the court. My name is, Your Honor, and Chief Justice. My name is Che Bonner Walton. I, along with my co-counsel, Katie Resnick, represent the petitioner, Judge Williams. I will discuss the first issue, whether petitioner has standing to bring suit in accordance with the case and controversy requirement of Article 3 of the Constitution. My co-counsel will discuss the second issue, whether the Voter ID and Anti-Voter Fraud Act violates both the political speech and voting rights protected by the First Amendment and the Equal Protection Clause of the 14th Amendment. Would the court like a factual recitation?
Briefly, please.
Judge Williams was married on July 5th, 2012. The next day on July 6th, she submitted documentation for a new photo ID at a photo ID center in the state of Texas. On July 7th, she went to the polls to vote in person. She presented a photo ID with her maiden name, King, and supplemented it with a copy of her marriage certificate, which was issued by the county clerk of the state of Texas. A poll worker told her that her photo ID was invalid and that the marriage certificate was not sufficient to supplement her photo identification. Judge Williams did not fill out a provisional ballot, and she was not offered a provisional ballot. A provisional ballots require an affidavit swearing to your identity or lack of a photo ID, and they must be supplemented with a valid photo ID within 72 hours. And that is the end of the recitation. I'm now going to go into the rules of law governing standing. U.S. Constitution, Article 3, Section 2, Clause 1. The case and controversy clause of Article 3 of the U.S. Constitution requires that cases have at their core an identifiable controversy that may be remedied. And under Lujan versus Defenders of Wildlife, courts apply a three-pronged test to determine whether a plaintiff has standing. However, only the first two prongs in this test are under contention. The first prong states that the plaintiff bringing the suit must have suffered an injury in fact, an invasion of a legally protected interest which is concrete and particularized, and actual or imminent. The second prong states that there must be a causal connection between the injury and the conduct complained of. The injury must be traceable to the challenged action of the defendant and not the result of an independent action of a third party not before the court. Petitioner, who has the burden of establishing standing, has successfully done so in the suit because her denial at the polls due to an invalid photo ID is a concrete and particularized injury which infringes on her constitutional right to vote. Therefore, petitioner is asking the court to find that she has satisfied prongs 1 and 2 of the Lujan test, which is sufficient to confer standing. On the issue of standing, I would first like to discuss injury in fact. The authority governing injury can be found in Babbitt versus United Farm Workers, which states that a plaintiff who challenges a statute must demonstrate a realistic danger of sustaining a direct injury as a result of the statute's operation and enforcement. And the other governing authority is found in Village of Arlington Heights versus Metro Housing Development Court, which requires a personal stake in the outcome in order to obtain federal jurisdiction. I would like to cite to a persuasive case in Common Cause for Georgia versus Billups. In this case, the two plaintiffs were in the state of Georgia. They went to the polls on election day in order to vote, and they were denied because they did not have a valid ID. The plaintiff's argument stated that the requirement of an acceptable photo identification was a denial of equal treatment. They said that they were treated differently than others who had valid photo identification, and their argument should be sufficient to confer standing. The court in that case did cite to the Supreme Court, which is an authority, and they said that the Supreme Court rejected the notions that injuries must be sufficient. They said that a small injury is sufficient to confer standing. And the court governing Common Cause Georgia held that a denial of equal treatment is an actual injury, even when the complainant is able to overcome the challenged barrier. They said that when the government creates barriers that makes it more difficult for members of one group to obtain a benefit that's easier for members of another group, those who belong to the affected group don't need to argue that they would have attained the benefit if not for the barrier. Rather,
Counsel.
Judge Peterson, I defer to you. Counsel, what is the personal issue with respect to her complaint here versus women in general or other voters?
Well, Your Honor, the petitioner is making the argument that the requirement of a valid photo ID in order to vote in person at the polls was prevented her from exercising her constitutional right to vote, and that itself is an injury.
Even though she could have voted earlier.
Your Honor, she did have the ability to complete an absentee ballot or an early vote ballot. However, she wanted to exercise her constitutional right to vote at the polls in person on election day.
Okay, thank you.
Going back to the holding and common cause, one thing that the court said that the court held, and we would like the court to adopt the standard, that requiring voters to produce a photo ID in person at a ballot or casting an absentee ballot, which requires a photo ID, should be sufficient for injury, should be sufficient to show that there is an injury, which should allow for a plaintiff to argue that they have standing.
Counsel, one of the things, sorry to interrupt you, but one of the things that I'm struggling with, and I think you just touched on it right now, is you're asking this court to set a new standard. Why is this not an issue that should be best left for the legislature to properly prescribe laws and rules that may apply? You realize you're asking this court to set a new standard, it sounds like.
Chief Justice, I do agree with you that that specific matters should be left to the legislature in regards to the decisions on how they should regulate voting and their requirements. The issue here, and why we're here before the court, is this is an infringement on a constitutional right. And when these voting requirements become unconstitutional and they're preventing individuals from voting, that's when we believe that the court should step in and create a new precedent to make sure it doesn't occur.
Well, when you say it, they're preventing individuals from voting, are you familiar with the statistics on how many voters or potential voters could be potentially impacted by this? And are you familiar with the statistics, including those cited in the materials regarding the number of instances of voter fraud and abuse?
Yes, Your Honor. I do believe that citing to the writ, they stated that within the past 20 years, there had only been 35 state prosecutions for voter fraud. And when we were looking at the statistics, 300,000 registered voters currently lack access to an updated ID. Out of that percentage, 66% of them are women, and 33% of that group do not have the correct name on their ID. And it's not just specifically targeted towards women. If you look at the statute itself, for example, there is a 10-day waiting period in order to get a new ID in the state. And so if there is an instance where an individual is ready to vote in person on the week of the election and they lose their ID, the statute offers no sort of remedy in order for them to be able to vote. And in addition to that, one argument that we did want to make is that the future probability of injury would be sufficient to confer standing. Citing the Massachusetts versus EPA, they did say that the probability of future injury is sufficient. As the record cites, one of the biggest group of supporters for Judge Williams are nuns. And these nuns are people who come, join a covenant. They don't have a need for a driver's license because they don't drive. Against their religious beliefs, they don't believe that they should use firearms, so they wouldn't have a concealed carry license. And the way that the statute is set up now, these are the kind of people who are going to be impacted. And not just them, you can also make the argument for indigents as well. The state has shown that they have closed they only have 2 open voter ID centers in the state. And in order to even get an ID, you would have to drive to those offices. And so if you don't have a valid driver's license or you're having difficulty with transportation, it's going to be very difficult for you to obtain an ID to vote.
Mr. Bonner-Walton, again, something I'm struggling with, no disrespect to the nuns, is what's wrong with a rule requiring a citizen to carry current identification? I mean, isn't there huge benefit to citizens carrying identification in the event that there's an accident or a death, or identifying them somehow, if a law enforcement official needs to identify them? And so I'm struggling to understand, why is that such a great burden whether you happen to be a nun or an indigent, because there are programs that allow for, if a voter, for example, wants to be proactive, there are plenty of programs that allow for that citizen to be, say, armed with a proper identification.
Chief Justice, I am in agreement that the requirement of having a valid photo identification is definitely beneficial to the state, whether for elections or for any other purpose. However, the issue that I have with this act is the steps that the state of California has taken to make it seemingly more difficult for individuals to get these. You have the closing of the voter ID stations, as I stated earlier. More importantly, if you look at the history of the past, if you look into the history, California used to have more relaxed rules. They used to allow people to supplement their photo IDs, even if they were invalid, with utility bills or birth certificates. When registered voters wanted to participate, as soon as they registered, they received a certificate that they could present. And these are the issues that we're discussing. It's not the fact that these IDs are required. It's just the difficulties that this act is making, that is creating the barriers, if you will, for individuals to access this. And they used.
Isn't your argument also opening? You're pointing out what is a generalized injury, an injury to all members of the state, not a particularized injury to petitioner in this case. Doesn't that undermine your position with respect to standing, that there is a particularized injury to the petitioner?
Your Honor, I would actually like to cite to the case law that controls that. In Lujan, as you stated, a precedent is created where it says, upon a common understanding of what activities are appropriate to legislatures, executives, and courts, which means if they believe that if they believe that it's proper to do so, they will. And I want to cite to another case, FEC, which made the argument for generalized grievances. In that case, the FEC made an argument that that generalized grievances are unable to confer standing. They stated that where a large number of Americans are harmed, the political process is more appropriate in regards to a widely shared grievance, as stated in Lujan. However, in that case, the court held that courts can still find an injury, in fact, where harm is concrete and widely shared. They said the fact that a political forum is readily available does not disqualify one from an Article 3 claim of case and controversy. And that example is stated in the case Massachusetts versus EPA. The state of Massachusetts stated that they were having issues with their shoreline, and they were attributing those issues to global warming. Although they did not succeed in the case, the court did find that the plaintiff experienced a particularized harm, even though global warming might be said to reasonably affect the entire planet. And for my last issue of causation, Lujan states that standing depends considerably upon whether the plaintiff is the object of the action. If there is ordinary little question that the action or inaction has caused their injury, and we believe that the injuries to petitioner were a direct result of the act. The petitioner was registered and eligible to vote, but she was denied for not showing specific form of photo ID, and she was not offered a provisional ballot. Therefore, petitioner is asking the court to find that she has satisfied prongs 1 and 2 of the Lujan test, which are sufficient to confer standing. I'll now pass the issue to my co-counsel, Katie Resnick.
May it please the court. My name is Katie Resnick, and I'm here representing the petitioner, Judge Jane Williams. The questions I will be addressing today are in regards to the First Amendment freedom of speech, as well as the 14th Amendment equal protections. We ask the court today to hold that there is a First Amendment right to vote, as well as that there is an equal protection violation here, holding that the California voter identification law is unconstitutional. I'll begin first with voting. We contend voting is a First Amendment fundamental right. The First Amendment guarantees freedoms to religion, right to petition, and expression. And we believe that the right to vote gives the populace a voice. They get to have a say in the election and the laws that we live under. Citing to the Supreme Court case of Rumsfeld versus Forum for Academic and Institutional Rights, this court reiterated that the First Amendment protects speech, as well as certain kinds of conduct. The court went on to underscore that that kind of conduct is conduct that is inherently expressive. That is the type of conduct entitled to First Amendment protection.
So I understand the holdings and the reasons you're citing those cases, but I want to ask you to get away from the law and just kind of enter reality for a minute. I take it you have voted at some point in your life? And
Yes.
so when you enter the voting booth and duck into the cloaked area and select candidates that you're voting for one by one by pressing a button and depressing and submitting that these are confirming that these are the candidates that you're voting for. Is it really your position to this court that that is a communication?
Yes, Chief Justice, it is. And let me explain why. We believe when you, or we contend, the petitioner contends that when you go to the polls, it is maybe not explicit, but it is an implicit way to explain your views. By voting for a certain candidate, it is still expressive, implicitly expressive at that matter, because it's a form of political expression. And when you are agreeing or disagreeing with a certain candidate, when you go into the poll, you're expressing your belief by voting for a candidate or not voting for a candidate. And so I understand how it could be from your belief asking, is voting just procedural? But we disagree. And the petitioner contends that when you communicate your views in this way, it's not just a yay or nay type of vote, and that you are expressing your beliefs when you go to the voting polls. Further, if it were simply procedural, based on a policy argument, then election outcomes would probably have little sway on the politicians and their behavior. Why would politicians spend so much money on campaigns to try to elicit certain votes if it was just going to the ballot and just checking?
Counsel, if this court were to disagree that the right to vote falls under a First Amendment protection, does petitioner have any other arguments as to why, or any other arguments with respect to the right to vote besides the First Amendment?
Yes, Your Honor. And to finish up shortly, to tie this into my next argument, we believe that whenever anything is fundamental, such as the First Amendment right to vote, it should be applied through a strict scrutiny analysis. And so in addition to the fundamental First Amendment right to vote, fundamental to our society, the court should use that analysis similarly in an equal protection violation as well. And I will continue on to my next point. When we move on to equal protections, we believe strict scrutiny should be applied here instead of the Burdrick v. Takushi test that respondents will contend are the right test in place. The Burdrick v. Takushi test is a balancing test, which weighs the interests asserted in the state's interest against the character and magnitude of the asserted injury to voting rights. But we disagree, and we believe that a higher level of scrutiny should be applied because this is a fundamental right. We also would like to explain why the Burdrick test is different than our case here. The Burdrick test was used in a case in which a voter went to the polls and wanted to write in a vote. And so it was about the content of the ballot, whereas here, the case at bar we're looking at is whether or not there is access to vote, a fundamental right. And so we argue that this claim is directly related to an individual's direct access to the ballot, and in doing so should receive a higher level of scrutiny. The respondents will also continue, they will likely cite to an argument from Crawford v. Marion County Election Commissioner, which is a case most similar to the case on point because a voter ID was required in that case. But I'd like to cite to the language of the court saying that with a right of access case, this does not foreclose on the possibility of implementing a higher standard of scrutiny should the burden be greater. So while the Crawford court did grant a fundamental right to vote, we asked a court to apply a strict scrutiny that's typically afforded to all First Amendment cases. The dissent in Crawford stated that the rigorousness of our inquiry into the propriety of state elections depends upon the extent to which a challenge regulation burdens both the First and the 14th Amendments. And so I'd like to cite to some statistics that my co-counsel already stated in terms of what effect is voter fraud having in Texafornia, such that Yes, Your Honor.
Can I jump in there? We all know the statistics. So rather than citing the statistics, why is that important to your argument?
Just to clarify, Your Honor, the statistics or voter fraud?
Yeah, no, you were about to go, I believe you're about to go into the statistics. We all know them. Give us your conclusion.
Yes, Your Honor. So our conclusion is that for an equal protection clause with a strict scrutiny standard, in fact, the state's interest that voter fraud is the reason for having more restrictive standards is not compelling, and neither is it narrowly does it have a narrow interest. And so to continue on why we state that, this restrictive voter law affects majority women who comprise 53% of the voters, and women who are, as stated in the record, the amount of women voting is projected to steadily increase over the next 5 years. And so our ask from the court is to determine that the state interest here is not compelling, as stated by the statistics of my co-counsel, in addition to the level of burden that these women face when this voter fraud act is legislated. The act's intent to cut down on voter fraud through the burden that's placed on thousands of women, we argue, constitutes invidious discrimination. The Crawford court says a law may constitute invidious discrimination subject to the highest level of scrutiny, even if the state's rationale is reasonable, so long as its restrictions are irrelevant to the voter's qualifications. Citing a case that Crawford cited to, Harper v. Virginia Board of Elections, another Supreme Court case, there was a poll tax, and they asked voters to spend money to vote because it showed how much they cared about the election. It was held in that case that that was irrelevant to the qualifications of the voters. So here, asking women who come to the polls versus, or not even women, anyone who comes to the poll to have an ID versus someone who would prefer to vote absentee or provisionally, that is irrelevant to the qualification of the voter. If a woman such as Judge Williams or anyone, in fact, wants to vote at the polls because that's their fundamental first right to do so, they should have the ability to do that. And so we believe that the distinction required to vote at the polls versus requiring to vote absentee or provisionally is unrelated to the individual's qualifications to vote, and is therefore rational.
Isn't early voting and provisional voting, aren't these measures that are really done as matters of convenience? In other words, if someone knows, for example, they're going to be getting married and may have an issue with their license, or someone knows they're going to be traveling and maybe away, there are ways to assert your right as a voter. And so again, I'm struggling with the argument here, because where's the abridgment? The person, if with a little advanced thinking, can vote.
Yes, your Chief Justice, let me answer that question for you, directing to you to a Supreme Court case called Kirchberg v. Feenstra. And there was an argument in that case in which the husband in the case focused on steps that the wife could have taken to preclude her husband from mortgaging their home without consent. So similar to the argument you're making, couldn't Judge Williams have gone to the polls if she knew she was getting married to vote early? The court in that case did not agree with the argument, saying that someone could have taken steps to avoid the impact. That's not what matters. It didn't matter if, quote, Judge Williams was the architect of her own predicaments. What matters here, what is critical, is did this have a discriminatory effect? And so we contend that the critical question is, did the act have a discriminatory effect? Yes, it did. And further, is it substantially furthering an important government interest? No, with the lack of minuscule. May I conclude briefly? Thank you. With the minuscule effect of voter fraud in Texafornia, there was not a compelling government interest. And in conclusion, we ask this court to hold that there was a discriminatory intent, further an invidious discriminatory intent. You should strike down this act because it rests on gender-based animus, does not compel a further state interest, and using a strict scrutiny standard, it does not meet the standard applied in in overturning the lower court and the Court of Appeals. Thank you.
Thank you, Ms. Resnick. If you would just give us a few minutes before the next speaker goes. Judges ready?
Yes, Chief Justice.
For the respondents, who will begin?
Your Honor, may I please the court?
Yes.
My name is Michael Moore, and my co-counsel Samuel Hooper and I represent the state of Texafornia. We will show why the 14th Circuit Court of Appeals correctly held that the Honorable Jane Williams did not have standing to bring this case forward in accordance with Article 3 of the Constitution. We will also show how the Voter Identification Anti-Voter Fraud Act does not violate the Free Speech Clause of the First Amendment and the Equal Protection Clause of the 14th Amendment. We will be asking this court to affirm the ruling by the 14th Circuit Court of Appeals. I will begin by explaining how Judge Williams did not have standing to bring this case forward. Article 3, Section 2 of the United States Constitution outlines the judicial authority power and defines this power using the terms case and controversy. Judge Williams, as the party filing suit, must meet this definition to allow the judiciary to hear her case and potentially grant relief. The understanding of case and controversy in this context has been the subject of prior case law and will guide our judgment on this issue. But the state would like to first acknowledge that the legislation in question was not designed to target women that decided to get married shortly before Election Day. While we do believe the petitioner could have taken steps to mitigate the issue, such as scheduling her wedding date sooner or voting during the early voting period prior to her marriage, the state sees the value in amending Section 12 of the legislation to allow someone in Judge Williams' situation to cast a provisional ballot at the time of voting, as opposed to striking the law altogether.
Counsel, are you asking this court to amend the act today?
Your Honor, I understand that you will be considering a variety of options in your ruling, and I am communicating on behalf of the state that is one potential opportunity that we could see as making a change without striking the law down altogether. And so just to clarify, Section 12 of the legislation only allows a provisional ballot to be cast if there's a religious objection to having your photograph taken, or if a natural disaster prevents your photo ID from being obtained. And so in this statement, we acknowledge the fact that the legislation was not intended to target someone in Judge Williams' case. And we also see the value in her being able to cast her ballot.
Counsel, you're talking about the intent to target individuals such as the petitioner, but wasn't it easily foreseeable that a situation like hers, where there is a wedding and a name change, that these things don't happen in a vacuum, and certainly she's not the first individual to face such a situation. So is intent really even relevant to any part of our analysis here? And if so, doesn't the foreseeability of this kind of situation equally satisfy whatever element that is?
Yes, Your Honor, I believe in this situation, I believe what the state is we are attempting to communicate is that there is a balance between being able to secure the integrity of the election through the legislation in question, while also making sure someone in Judge Williams' situation is able to vote. So moving on to the case law as mentioned, in Lujan v. Defenders of Wildlife, plaintiffs were endangered species advocates who argued that they were injured by a lack of consultation for governmental activities abroad, which allegedly led to an increase in the rate of extinction of endangered species. The court proceeded to establish a three-part test. Part one requires an invasion of a legally protected interest, which is, quote, concrete and particularized. And it's clear that any allegation of such invasion by Judge Williams is not concrete and particularized as required by the test. She is asking the court to rule on the merits of the before mentioned Voter ID and Voter Fraud Act by alleging negative implications by the legislation towards Texafornians anywhere. As the 14th Circuit ruling noted, legislative debate and public policy decisions are matters of the legislative branch and not the judicial branch.
Counsel, sorry to interrupt you, but since you bring up the 14th Circuit, I want to speak about Judge DeBracchio's concurring and dissenting opinion. And I have three specific questions for you. The first one is was Judge Williams a voter?
Yes, Your Honor.
Was Judge Williams a citizen of the state of Texafornia?
Yes, Your Honor.
Did she not have the ability to vote restricted in some manner?
Your Honor, and she did prior to Election Day, Your Honor.
Well, then how is she not a member of an affected group of citizens? And if you would address that point from the dissent, that would be helpful.
So, Your Honor, I believe in this case, as I mentioned previously, she did have that opportunity to vote before Election Day. Again, I would just like to reemphasize my previous point, which is there is a balance that I believe we can strike here in making sure she's able to vote before Election Day while making sure the integrity of the vote is protected. And so I think to answer that question, I communicate the state's point of making sure that steps can be taken to make sure those that intend to vote are able to vote. And so moving on to the next case, Massachusetts versus EPA dictates the standing required to be a truly adversarial relationship. Opposing counsel argues that Judge Williams' voting rights and the enacted legislation are adversarial. We believe this is a slanted view of the legislation, as the legislation will actually strengthen voting rights for eligible voters by preventing voter fraud activity from having the ability to dilute the legal vote. The dissent, as you mentioned, Judge, in the 14th Circuit Court of Appeals ruling, erroneously viewed the voter ID requirement as a harm that impacts Texafornia citizens as a whole. This point is made in an intent to portray the harm alleged as concrete and particularized. Once again, it's a misconception, as it's documented that the legislator's goal in enacting the legislation is to decrease the currently rising number of voter fraud incidents. There are DOJ statistics that guide the lawmaker's judgment, and the judiciary should defer to the legislature to make public policy decisions. Ultimately, petitioner has not demonstrated that her harm was specific and concrete. In addition, it's clear that her harm was avoidable, but she failed to take steps to avoid being denied her vote at the poll. For these reasons, petitioner has failed to show standing for the suit to be allowed. This is why I'm asking this court to affirm the 14th Circuit Court of Appeals decision and rule that petitioner does not have standing. I will now turn it over to my co-counsel, Mr. Hooper, who will discuss the second issue in the case.
Thank you, Mr. Chief Justice, and may it please the court. Sam Hooper for respondent, the state of Texafornia, and mirroring petitioner, I would like to first address petitioner's First Amendment and then 14th Amendment claims. This court's jurisprudence concerning voter regulations has always shown due deference to the state's legitimate interest in heading off rising levels of in-person voter fraud and securing the election process from that risk, and has shown due deference to state governments as they attempt to craft solutions that fit their own unique circumstances. Now, the state of Texafornia has relied on this supportive and deferential jurisprudential environment when it crafted the Voter Identification and Anti-Voter Fraud Act. Like an increasing number of states, Texafornia sought to head off those rising levels of in-person voter fraud and falling public confidence in the electoral process by moving to a system of photographic voter ID. Similar measures by states such as Georgia and Indiana have passed scrutiny either by this court or by circuit courts following Supreme Court precedent. And it's in this context, Your Honours, and following clear stare decisis from Bernick versus Takushi and its progeny, including Crawford versus Marion County Election Board, that this court should affirm the 14th Circuit's decision upholding the Texafornia voting law. Your Honours, this is a case where even if the court does share some of petitioners' concerns about the scope of state authority to craft local voting regulations, this case is a uniquely poor vehicle to craft a new exception to your current precedent because the facts here are so particular and coded to the experience of one individual. So with that said, I'd like to move first to the First Amendment claim, mirroring petitioner. So the dissent in the 14th Court of Appeals placed great stock in the importance of voting as an expression of the voice of the people. But this court, while obviously maintaining the strongest protections for free speech, has been consistent in viewing voting as the procedural and transactional activity that it is. Now, we certainly concede that voting in aggregate as the people may be a form of collective speech, and the voice of the people, when expressed in an election result and everyone can pore over the returns and the polling, may have some expressive element. But the voting of one individual doesn't do that. It's a binary exercise in voting yes or no. It's inherently administrative in that way. And in line with this court's past precedents, we would say that that does not count as speech. Now, Your Honour, as the court noted in Burdick versus Takushi, that's the Hawaii case concerning write-in votes, I'd like to quote, "The function of the election process is to winnow out and finally reject all but the chosen candidates," end quote. So it's inherently a selective function, not an expressive one. And even as Justice Kennedy noted in his dissent to that case, he was otherwise quite unsympathetic to Hawaii.
Mr. Cooper, forgive the interruption, but let me get to my question. The petitioner claims that the act must satisfy intermediate scrutiny. Why do you believe that is? Let me just ask you generally to tell us, what standard do you think we should apply, and why are they wrong about the standard that they say we should apply?
Yes, Mr. Chief Justice, it's our contention that whether this court applies strict scrutiny or intermediate scrutiny, and traditionally in terms of voting rights cases, this court seems to have crafted a unique approach somewhere between the two, that in either case, the Texafornia voting law would be upheld as valid. So if one were to apply strict scrutiny, for example, in that case, there would have to be a compelling state interest to overcome the incidental burden placed on voters. We believe that that's more than upheld, given the history of voter fraud, the fact that it in fact doubled, albeit a large percentage increase based on small numbers, but still doubled in terms of in-person voter fraud, and just the plummeting rates of voter confidence in the outcome of elections. So we believe that under strict scrutiny, that the Texafornia law will be upheld. Even more so, Your Honours, under the intermediate scrutiny.
But Mr. Hooper, so is it a strict? Should it be a strict scrutiny standard or not?
Your Honours, we contend that it should not be strict scrutiny. I mentioned strict scrutiny only to illustrate that even if this court were to apply that standard, then Texafornia should still prevail.
I find the evidence of voter fraud not compelling. Are you suggesting that it is compelling and that has some effect upon this analysis?
Your Honours, I'm suggesting that the state's overall interest in maintaining not just secure elections, but public confidence in elections is compelling enough to satisfy strict scrutiny. So as you say, the proven cases of in-person voter fraud are small, but that's not the only state interest that Texafornia alleges. We also allege an importance in safeguarding public confidence in election results. Public confidence can be harmed by even one case of voter fraud, and it can also be harmed by delays in being able to to report the outcome of an election, which can happen when you have to undergo many days of curing provisional ballots and so on, which is one of the reasons why the statute sought to limit that period. So the state's interests are compelling beyond just the actual proven cases of voter fraud that have taken place.
So then are you conceding the injury?
Your Honours, we don't concede the injury. I think petitioner made a telling statement mentioning that Williams was, quote, the architect of her own predicament. And that's very much our contention here. Petitioner had opportunities to, since this law came into effect in the beginning of 2012 and her marriage took place in July of 2012, as a particularly engaged member of the community, as a judge, she had ample opportunity to comport her behavior and her administrative actions in line with the statute, either to have availed herself of early voting, to have married at a different time earlier than so close to the election so that she could have had her new identification ready. There are a number of opportunities that she could have taken, and to paint herself as injured or as a victim.
Are you really telling us that she should have gotten married at a different time so she could vote?
No, Your Honours.
In light of the new law?
No, Your Honours. It's simply the state of Texafornia's contention that any new limitation on voting, and this court has long upheld that the states need to, in some ways, change the voting laws, is going to impact people at the margins, people who happen to fall one day shy of a new deadline for registration, perhaps. That's inevitable. When you change the law, there will be winners and losers. In this case, petitioner is not a particularly sympathetic plaintiff. You know, she is not indigent. She doesn't suffer from any financial constraints. Her failure was a bureaucratic and a procedural failure, which she had ample opportunity to remedy before election day. So we do not concede the point that she was injured in that regard, Your Honour. So I'd like to go on just to mention that as well, the standard for most facial constitutional challenges requires the plaintiff to establish that the statute's invalid under all of its applications. But even under the more permissive First Amendment standard, the statute can only be invalidated if a substantial number of its applications are unconstitutional compared to the statute's legitimate sweep. That was emphasized again by this court in Califano v. Webster and in Crawford versus Marion County Election Board. And that hasn't happened here. That the court has to make every reasonable construction to save a statute from unconstitutionality. And I think the petitioner here hasn't met that burden. Your Honours, moving on to the 14th Amendment claim, this court has long emphasized that, quote, the right to vote is the right to participate in an electoral process that is necessarily structured to maintain the integrity of the democratic system, end quote. So this court said that in Burdick versus Takushi, the 1992 case out of Hawaii, and the right in voters. And it instructs courts to weigh the character and magnitude of the injury on one hand versus the state's legitimate interests on the other hand. And as the court noted, if you subject every voting regulation to strict scrutiny and require it only be narrowly tailored, it would tie the hands of any state seeking to fulfill its basic function of administering democratic elections. So the upshot, Your Honours, is this. When a state regulation imposes a severe restriction, the court can insist that it be narrowly drawn to advance compelling state interest. And that's appropriate only where the burden is severe, as we see in Justice Scalia's concurrence in Crawford. But where the restriction is only reasonable and non-discriminatory in nature, the state's regulatory interests are generally presumed sufficient to justify the regulation. So as I was saying earlier, talking about the standard to apply, we believe it's that latter standard that should apply here. Now, petitioner makes much of the fact that other photo voter ID cases that have been considered and upheld by this court have involved identification cards that are free. But it's important to note that this court has never held that to be the critical factor. In striking down the Georgia law in the state of Common Cause, Georgia, The 11th Circuit, following this court's precedent, held that because the burden of producing photo identification is not severe, the statute need not be narrowly drawn or in the least restrictive. It doesn't talk specifically about free voter ID as other states have implemented, and that just reflects this court's willingness to allow different states under our federalist system to pursue different approaches as they seek to tackle their problems. Now, petitioner also makes much of the fact that certain elected officials in Texafornia have made some ad hoc statements, which if you view them uncharitably, could be indicated to have a partisan intent. But this court was faced with just such a similar case in Crawford versus Marion County Election Board and still found the voting law to be valid. The Supreme Court, this court found that while partisan considerations, if they were the sole justification for the new law, then that could represent a violation of the 14th Amendment. But that if a non-discriminatory law is supported by valid neutral considerations, then those valid considerations can't be ignored just because they're in tandem with partisan.
Mr. Cooper, again, I apologize for interrupting you mid-sentence, but you do agree that more females historically have changed their names following marriage, right?
Yes, Your Honor.
And so don't you think that there is a greater tendency that females will be discriminated against based solely on their gender, given that that portion of the population will find themselves in this unenviable position of having to update photo ID often?
Mr. Chief Justice, I believe Your Honor is raising a point concerning disparate impacts. And we would certainly agree that unfortunately, as with any state regulation that seeks to set limits, the burden may fall more heavily on one group than another. That is regrettable, but inevitable in any law. However, we would add that the key here is intent. It's not sufficient for petitioner to show disparate impact. It's not sufficient for a petitioner to even show particular harm in one case. There has to be intent on the part of the legislature to have caused that disparate impact for a partisan reason. Petitioner has not met that burden here or even really attempted to. In the case of Burdick, which has been much mentioned, the court noted that even legislative history or prejudicial remarks by a congressman or politician aren't enough. We see in the records here that unfortunately there was a Texafornia politician who made some condescending and demeaning remarks about certain voters. But again, that isn't enough when the legislature has a clear imperative and there's an otherwise justifiable intent to implement the law. And Your Honors, as well, we see just a similar line of reasoning in another Supreme Court case in Village of Arlington Heights versus Metropolitan Housing Development Corporation, which involved the challenge to a denial of rezoning request made on the theory that rezoning the granting the agreement would mean that more racial minorities would come into an area. And so they were claiming disparate impact based on race in that case. However, the court made it clear that in order to prevail, just as here, a party claiming racial discrimination must show proof of discriminatory intent or purpose. Disproportionate impact there, again, was not enough. And so there's a very clear, I think, precedent from this court to that effect. And finally, Your Honors, petitioner seeks shelter, partly in Justice Souter's rather forensic dissent in Crawford versus Marion County, in which Justice Souter refused to take the state of Indiana's assertions of a compelling state interest at face value. But whether the particular election security measure in question actually makes the vote more secure, or perhaps just simply benefits democracy by increasing the public faith in the democratic process, ultimately, questions like this are a quintessential political question that we believe are best left to the democratically accountable elected legislatures of states to decide. Going really into the weeds of once you've failed to prove discriminatory intent, as we believe petitioner has, we believe that the judicial branch is beyond its traditional zone of competency in trying to second guess the decisions of an elected representative or elected legislature. So we would note that overall, the court has established a solid line of jurisprudence which protects voters from egregious infringements on their First and 14th Amendment rights, while maintaining due deference to state governments, sovereignty as states seek to administer their elections. This law really is modeled very closely after other statutes that this court has upheld in Indiana and in Georgia. Texafornia has relied on Supreme Court precedent to a large extent in crafting its own legislation. So again, for that reason, we believe that this statute deserves to be upheld. Sorry, did I hear a question? Okay, my apologies. I would note as well, Your Honours, that in the dissent in the court below in the 14th Circuit, it strikes what we certainly consider a rather uncomfortable paternalistic tone, where the dissent literally...
Mr. Cooper, I
Yes.
think you invited a question and the court will indulge you. I think I heard co-counsel say that some modification of the act would be in line without necessarily striking it, and that the state is open to that. If we were to take you up on this opportunity to legislate, decide, how would you like us, or what suggestion do you think we could make to the act without striking it as unconstitutional?
Well, Mr. Chief Justice, first and foremost, it would initially be our contention that the Texafornia statute is fine as is. But if this court were to find otherwise, then we believe that taking an approach similar to Georgia, where in response to a district court injunction, the state of Georgia added public education requirements about the new law so that the broader public had a greater knowledge of what was coming down the pipeline and time to cure their behavior to get their IDs in place would be one potential remedy. But again, we believe that that isn't necessary. We believe that Texafornia has crafted a law that's really fully in keeping with this court's precedents. And so, Your Honours, even if this court does share some of petitioners' concerns, we believe that that it's not necessary to overturn this law in keeping with precedent. And so, Your Honours, for the foregoing reasons, I respectfully request that the court find in favour of respondent, the state of Texafornia, and uphold the voter identification and anti-voter fraud statute as constitutional, overstanding the First and the 14th Amendments. Thank you, Your Honours.
And that's time.
Thank you, Mr. Cooper. I think the judges will take a couple of minutes on our ballots.
Do we have any rebuttal?
Yes, Your Honor.
Justices, are we ready for the rebuttal?
Yes.
You may proceed, counsel.
Thank you, Your Honor. The respondent says in either a case of strict scrutiny or intermediate scrutiny that the Texafornia voter ID law would be upheld. We disagree. Under a strict scrutiny standard, this voter ID law would not be upheld. A strict scrutiny standard says that the government must show there's a compelling interest that is narrowly tailored to achieve this interest. First, voter fraud in Texafornia is not compelling, with the incidental voter fraud cited in the record, as well as stated by the respondent. In fact, the law also affects and burdens a majority of women over men, as well as having low numbers of voter fraud. Even if the court upheld this interest to be compelling, it is not narrowly tailored, because if it were narrowly tailored, it would include excuses or other ways for those who did not have an ID to come and vote at the polls under their fundamental first right. The prior law of Texafornia did allow for voters who didn't have proper IDs to use a marriage certificate, a utility bill, or a bank statement, other governmental documents to vote in the circumstances such as the one that Judge Williams was put in. But this is not the case now. This law affects several classes of people: women, indigents, those who could not afford a voter ID, as well as nuns who have religious reasons to not take photos. And finally, in response to the fact that this law promotes administrative efficiency, under the Michael M. v. Superior Court case, this may be true and this can be a weighty interest, but the court has consistently ruled that gender-based classifications may not be based on administrative convenience. And so in conclusion, we ask this court to use a strict scrutiny standard in which the respondent said could happen in this case. We believe there's discriminatory
Time.
intent. May I briefly conclude?
Yes.
Your Honors, okay. And a discriminatory impact by the restrictive voter laws. We ask the court to strike down this act because it rests on gender-based animus and does not further a compelling state interest, therefore overturning the lower court and the Court of Appeals under a strict scrutiny standard. Thank you.
Thank you, counsel.
All right, that was great. Would you like for me to put the judges in a breakout room to discuss while you take notes?
And
That'd
if you
be
could
great.
join us, that would be great as well.
Perfect.
Good job, everybody.
Thank you so much.
Thank you.
Thank y'all for your time.
Hold on, I guess we'll be back.
Yeah.
All right, I placed them all in breakout rooms, so just keep tight while they calculate the scores and we'll let you know the results soon. Great job, everyone. This was really entertaining to watch.
Thanks, Stephanie.
Yes, thank you so much for everything everyone's done to organize this tournament.
Can sit down now. Good job, guys. Y'all did great.
Likewise, yeah,
It's
congratulations.
the first round to the last round.
I know, right?
It comes
full circle.
Where did Che go? He might have left for a sec.
Sides too, same sides as the first round.
Was it? Yeah. Oh, I wonder, do they flip a coin to give us our sides? Is that how it works, Stephanie?
To choose what side you're going on?
Yeah.
No, I just did it random.
Oh, nice. Okay.
But it worked out because for the first one, you were respondent and then they were petitioners. So it just kind of switched.
Actually, I thought we were the
Yeah, I
petitioner.
think they were.
Yeah,
petitioner.
this was the same as it was in the first round.
Oh, it was? Oh, well, then it was a double practice.
No, it's fun.
I know, Katie, I feared your rebuttal just as much the second time as I did the first time. So.
I don't know if it was as good the second time because your arguments, I was like, he's flowing. I don't even know what I'm going to respond to here. It's too good. So
I had inside information that Che was going to give a rebuttal. I don't know.
I know. Threw you off there.
Oh, psych.
He messaged me and said, "Hey, I'm going to take that rebuttal." I said, "You may be messaging the wrong person."
Oh, Che, is that an accident?
It was an accident. I call it mind games, though. Strategic.
Yeah, for real.
Nice.
Well, the funny thing is I wanted Che to take this one because I've stolen all of them. But the thing is that, like, I think that my side has the better rebuttal. Like, I don't know. It's more, I think we can get past standing and then we can look at the rest of them and be like, there's actually stuff for us to argue a little bit more on the second question than the first question.
Yeah, if I did the rebuttal, I was just going to go after Michael for concrete and particularized, and we're going to talk about Lucian again. That was it.
That's too boring.
We have 7 people watching on the live stream, so
Yeah,
there
but
were
3 of them are probably my family.
We're happy to answer any questions while we have some downtime.
Yeah, feel free to put in the comments any feedback or just any comments.
Hi, Mom.
Steven said he was watching, but he said he fell asleep. I was like, I appreciate the effort. We need the views.
I'm gonna sleep after this. I know that much. Goodness me.
Oh my
I
gosh,
know.
haven't slept in like a week. I feel like we got more time last time around. I don't know.
It was intense.
It was a hard problem.
You know, if I have to be honest, I really feel like our first judge in the very first round, I think she really grilled us more than we got grilled with these questions.
Yeah. That was the
Yeah,
hottest bench I've had the
the hot
entire
panel.
time.
Mhm.
Yeah,
Mhm.
that was crazy.
Was that intentional, Stephanie? How some judges were hotter than others?
No, that's just up to them. But she actually told us that, yeah, that was a very hot panel. So it gave you guys good practice for this.
Mm-hmm.
So once we survived that hazing, then nothing else seemed quite so bad afterwards by comparison.
No, I agree.
I think I sometimes like the questions more because I feel more awkward when I'm just reading and like going through, my outline without any questions. I never thought I'd say that, but yeah, I don't know. Have I had a class with any of y'all, Michael or Samuel? Samuel, we had a class together, didn't we?
We have before, yes. I don't know if we do this semester.
Are you a 3L, Katie?
Yeah, kind of. I'm kind of a 2L. It's a long story.
2.5L? Okay.
That's how I said it before, 2.5L. Mm-hmm. Yeah. Were you an admin law, Samuel? Is that where I remember you from?
Yeah.
Oh, okay.
Professor Kumar's
Okay.
class, yes.
Okay, cool.
Those are the days.
Yeah.
Happy days. Did you take federal courts as well?
Me?
Hmm.
No, I haven't, but I want to.
Yeah, it was a tough class, but again, Professor Kumar, so she's good. She's on the singing.
Yeah.
So
Yeah, Chay's in that class right now, actually. So
Yeah, I have her for
Okay.
admin, and I'm taking her next semester for federal courts.
awesome.
Mm.
It's one of those
Michael-
classes that's like, oh, sorry, go on. Keith.
I'll see you.
Are
I'll
you-
see you in federal courts, Che.
Okay, good. We'll finally have a class together, Michael.
Yes, we can work together. We're not
I
against
know,
each
finally.
other. Yeah.
Because what's so funny about this is that Michael was also my first competitor for our mediation competition. It was who was it? It was myself and my mentee Muhammad Fato. He's a 2L. And yeah, we won against them first. So
Oh, wow.
Mhm.
Y'all are going to get all your credits for all the competitions.
I know.
It's good. That's great.
It's a good time to mention I'll be directing the Moot Court, John Black Moot Court competition in the spring. So y'all should definitely sign up for that.
What's the
similar-
difference from?
I don't know if Stephanie's still in here. There's no difference that I can think of. It's just moot style and just same
Closed
idea.
case again, or
What's that?
the closed case again, or is it open world?
Closed case. Closed case.
I thought John Black was just for 1L for some reason. I must have got my facts wrong.
It could. I guess I'll need to double check because I was a 1L when I competed in it.
Do any of y'all want to do appeals and like this type of stuff?
I would love
It
to.
seems too stressful.
Oh, really?
This seems really stressful. Like
I
they
would
were
check.
saying, like those responses. I mean, it's just so hard because I think we've all had the issue where you've got a flow going, and then all of a sudden, you get that one question where you have to be like, well, let me think about this for a second, and then trying to tie it back. It's definitely difficult.
I think it was Judge Peterson in our previous round that mentioned she uses some of the same style in her arbitration work that she does, mediation arbitration. So, I'd probably be open in that regard.
Yeah, I think I'm on ADR and having some like negotiation training has actually helped a little bit with moot court because you're kind of always prepared to try to have some sort of like reasoning, which I didn't really understand the first time I did moot court. So that's cool. It's cool that you want to do this though, Samuel. It's too stressful for me. I couldn't.
Sam, you have like the best flow, and I think with the accent
my
too,
gosh.
it's so easy to listen to.
Mhm.
To be honest, I skate by a lot on the accent, and it conceals under the surface a whole world of like logical non sequiturs and ignorance. But like
He could argue how the sky is green, and I would just believe it, just the way he speaks it into existence.
Actually, I got called out last time, like in our last round, that Judge Peterson said, your British accent doesn't get you any extra points. And I was like, darn it, I've met my
So
match
funny.
finally. So
Well,
Were
the judges
you-
are taking a long time, so I guess it was a
It
competitive
must be
round. That's a good
close.
thing.
I'm not
Sammy,
doing a
were-
tiebreaker. If there's a tiebreaker, I concede right now. I'm done.
Oh, there's
No.
no tiebreakers, thank
No
God.
tiebreakers. Yeah, I know that they'll go one way or another.
10-minute rebuttal death round. Here we go.
Oh my
no!
gosh.
Do they make it? Oh, that would be horrible. I shouldn't. I would hope in the instance like they would give us like a 30-minute like break to like come up with a rebuttal, because that would just be hard to just do like right now.
Oh my
Captain
gosh.
join us now. It's my cheerleader, Eliza.
Aw,
Oh,
she's so cute. It was good she didn't walk in front of your screen while you were trying to talk, because like everybody's cat does that.
Yeah, I kept her.
I could hear my cat clawing on my door to come in, but I said I gotta have this
Aw.
space to compete. So she's
Aw.
waiting outside.
Oh, it's so cool.
She was like leaving white fur all over my suit, and I was getting the lint roller like the second before I came on. I was like, damn it, kitty.
yeah. I've got two standard poodles who are staring at me from outside, wondering why I'm not playing with them right now.
Are the
Oh.
standard poodles the big ones?
Oh, they're. You want to see them?
Yeah,
Okay, hold on.
go. Is this what councils do after they finish the argument in real life and they're waiting?
It
They're
should
"Let me
be.
show you- Let me show you my
I think
dog.
it should be.
Yeah, bring your pets to work day.
I think that's becoming like more common practice now, which is pretty cool actually. I think it should. When Che and I were studying, he has a Rottweiler, and all I did the whole time, I'm just like petting the dog just for emotional support, because I'm like, I can't do this. It helps a lot actually.
That's awesome.
Yeah.
Yeah, my wife's company has like they have people, you can bring your dogs into the office in DC, and like one of them pooped on the floor right before a client meeting once. It was not
Okay,
cool.
yeah. This is
Oh, she's so cute.
She's adorable.
Hi.
She has a twin sister. They're identical.
She's just like going in and out of the camera. It's so funny actually. Aw.
Okay, all right. Leave me alone now. Okay.
Sam, your cat's getting some love in the group chat. Kim says your cat is so adorable.
Oh. Yeah, she knows it as well when she wants like stuff out of me. She knows how to manipulate me.
Mm.
I know. I think you need like an emotional support animal or like some companion to get through law school. It's tough.
Che
I
said the
couldn't
same
imagine
thing.
anyone who would do it alone.
Yeah. I have horses, but they're not at my house, obviously.
Wait, horses plural.
Or I ride horses. So
Amazing.
I get to see them. Yeah.
Dun, 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 dun.
I know. Oh, here we go.
We were showing off all of our pets, but while y'all were deliberating.
You should have done that before we scored you guys. I'm teasing, of course.
Would have been an unfair advantage.
Well, hello again, everybody. Now we're going to first announce the winner, and this is on advocacy, not merits. Team 6, the petitioner, is the winner of the round. So congratulations, Team 6. We thought the next thing to do would be spend a few minutes speaking about each of you, giving you some feedback, and each judge will speak about each competitor until we finish with our last. And so I guess we'll go in order. Michael, you started. I'm sorry, not Michael.
Che.
Shay.
Yes, sir.
You started, and I felt like there was a little bit of reading happening at the beginning. It's very difficult with this platform, Zoom. We're dealing with it. I did an arbitration yesterday, and there were definitely some things I needed to read. I don't know if it became obvious, but there are things we want to quote. I think at this stage, definitely at the finals, we want to try to do our best to not read. I'm going to make some very small minor nits just because I think you'll benefit from them. At one point, you said there is a casual connection. And I think what you're wanting to say is a causal connection between the act and the injury, right? And I think that's just a trip up because of the reading, and it's a little bit of nerves, right? It's hard. I felt like you knew the facts very well, and I felt like you had a good command of the case law. Probably just relax a little bit. I think you're a great speaker. You've got great poise, and don't be scared to look away from the notes, the record, the computer, whatever it may be. And with that, I'll pass to the next justice.
Sure. So Pete Patterson here. Che, I thought you did very well, and I've watched you in a previous round. And what it brings up to me is I've had some lawyers I've tried cases with over the years that they can be funny, they can be sarcastic, all that kind of stuff, and I can't. And some of the best lawyers I know have taught me to stick with my personality, which is basically just the facts, ma'am. Right? Just stick with what I know, stick with what I can do. If you're funny, you know it. If you have to ask people if you're funny, you're not, right? That's just one example. So I thought that you had I wrote it down, very even keel presentation. You're very comfortable and you seem very confident, and you should just run with that. Don't feel like you have to do more than that. I thought that was good. I'm going to go off script for just a second, if I can, Chief Justice, to everyone, because I'm not addressing this to Che. I'm addressing it to everyone. I think all the coaches saw what Matthew just said, which is if we see you reading off your screen, that's a huge no-no. And that's why the adage is speaking off your feet, right? Speaking on your feet, right? When you get up and speak on your feet, you're not looking at notes. You have to be able to address the justices, especially in person at the appellate court or Supreme Court. So to the extent that any of you are relying on notes, that's a big no-no, and people are going to realize it and see it. And all three of us saw it. And I'm not calling out any individual, I'm calling out the whole group. It's really important not to do that. Another big one that everybody did that you should not do, and you should bury this and never do it again. We hope that you will see, no, this is an appellate court. They don't care what you think. You have to tell them, this is what the law is, and this is why you should rule this way. And this is why they're wrong on their reading of the law. Nobody cares what Katie Resnick thinks about the law or what she's trying to convince the courtroom of. So those are just more general ideas for all of you. But Che, I thought that your presentation was exactly as it needs to be. It's clearly your presentation style. And don't try to get out of that. You don't have to try to be whiz bang or cute or funny or interesting or just the facts, ma'am, is fine. It works for you. I'll stop.
And I'll jump in very briefly. It's just occurring to me, you guys may want to know who we are. So I'm going to briefly introduce myself, and I'm sure the other justices will in the next comments. So I'm Carter Dixon. I'm a 2018 grad of the Law Center. I was the executive director of the Moot Court program and national champion twice in different competitions. Once in Greensboro, and then following up in San Diego, I was a best speaker at the criminal law competition. So you guys are all after my heart here, competing in Blakley Butler. I'm currently a fourth-year associate at Jackson Walker. I joined that firm just 2 weeks ago, so still getting my feet under me there. Was at Winstead for the 2 years before that. So with that, my comments will be brief. So yeah, Shay, echoing the comments we received from everybody else, but as the first speaker, you always have the hardest position, which is laying out in a succinct and persuasive way what the case is about. Always think about your elevator pitch for your first 60 seconds of an argument. You have the formal, the rote things you have to do as part of the moot court fiction, but always use the phrase in your own mind, what is this case about? This case is about, give me 2 sentences on what it's about before you predicate all of your law, your legal basis and issues and even the facts, because that sets your tone and it creates a theme for you and helps us really understand what we're supposed to be listening for. Also, you were one of the first speaker to go over your time. Everybody just remember that when you are coming up on 30 seconds and you've got a lot else to say, go ahead and very calmly make that full request. Your Honor, seeing my time is about to expire, may I finish my point and then briefly conclude? never sound rushed. So always be watching your time. And I know it's a little weird on Zoom, but having a command of your time displays confidence and competence. So with that, I turn it back over to the other justices.
Great. And one more question. Are you guys 2 Ls or 3 Ls or some and some?
I'm a 3L.
2L.
Got it.
2.5 L.
Okay. Got it. Okay.
Good.
So
Because if you guys had said 1 Ls, we were all going to fall over.
yeah. Well, the reason I ask is because, I feel like I knew you weren't 1 Ls, but I feel like, it benefits us to, be as candid with you as we can, because you're the lawyers that we're going to see at our firms or in court as adversaries. Maybe one day you'll be judges. And so we're just going to, shoot straight and invite you to receive these comments with love. So the other thing I wanted to say earlier is, even though there was one team that obviously scored higher, it was very, very close. I mean, really, really close. So the next speaker we had for petitioner was Katie. And I like what Pete said earlier about the reading. I'll just universally say we saw that. Shay, unfortunately, you got the brunt of it first because it was one of the things that I wrote, but it is hard to go first. But yeah, everybody needs to do less reading. I felt as though, Katie, you handled the questions well. Something you did that I liked a lot, that I didn't necessarily see with everyone else, was I liked your transitions. At one point you said, and to tie this into my next argument, very, very smooth, excellent skill as an advocate, especially in appellate advocacy, because judges will hammer you and get you off your order, your script, whatever it is that you want to say, that, and to do that you did a very good job. I also like that you asked a clarification question. I don't remember if it was me or another judge. Maybe it was Pete. Someone asked you a question and you said, just to clarify, Your Honor, in response to the question. And then I thought that was excellent. I think you've got a very pleasant demeanor. I don't know, like now I'm looking at your screen and it's not bopping at all. It seems static. I don't know if you had a bit of a static or an internet connection thing, or if maybe you were a little anxious. But we did see like a little bit of movement on the screen. We always want to be aware of what body signals, what messages we're sending. And so if that was just dealing with a little nerves, cool, take it, run with it, be aware next time, that those things are distracting, right? I think you don't want to do anything that takes away from your performance. And again, with this Zoom platform, little things are magnified. So just sort of be extra conscious of that. But I thought you did a great job.
Thank you. I will say, you know what? I didn't realize it. I have a standing desk. And so as I'm probably standing and talking, I may have been moving it. So I didn't know that. So thank you for saying that.
Okay.
Yep.
Right.
I'll make mine brief, as Carter did on Chay's. I saw the same thing. I saw you were a little amped up, and that's good. It's good to be excited and you want to get forward. But so I wrote down with a big exclamation point, breathe, right? Like breathe, calm down. Because it was kind of like the same as like a bopping knee, right? So be aware of yourself, be aware of how controlled you are and comfortable you are, and make sure that you breathe, whether it's in a courtroom or in a hearing or at an appellate court. And I wrote down the exact same thing, so I won't go through it. Good pauses and good transition. I wrote the same thing. You had a very good pause when I asked you a question, you said yes, and then you paused and went on with the answer. And then you also transitioned into the strict scrutiny conversation, which I thought was well done. And that's where you begin to, as the other lawyers on the phone will tell you, that's where you begin to really feel your own, where you can think ahead. I'm not just trying to get out what I need to say. I'm also thinking, okay, and how do I bring them to the next point? And then a very good sum up in your rebuttal. So anyway, good job overall. Thank you.
Yeah, I'll just provide only one additional comment. I know sometimes as a petitioner, especially at this point, you guys have had several rounds where you know both arguments, so you know exactly what you're going to hear from the opposing party. And frankly, if you're in an oral argument and you don't know what the other party is going to present, you're in trouble. But be careful in giving them airtime. So for the petitioner, I heard a lot of, you're going to hear the respondents argue. The respondents may argue. You don't need to do that because you did an effective job, as Pete noted in your rebuttal, of hitting those points that you know you're really going to want to rebut their arguments. But as a petitioner, especially, be making positive, affirmative statements of your position. Don't give respondents any more airtime than they're already going to get. But otherwise, very good.
Okay. So the next one, Michael. Michael, I love the way that you started out. You said, we will show, we will show, we will show. You kind of gave us I feel a very clear roadmap of where the argument was going. I think you as well are a good speaker. You made some concessions, some acknowledgments that substantively, I don't know necessarily I would have made those. I think generally speaking, I felt as though the lawyer I was looking at had candor. I didn't think you were trying to, pull a fast one on me in any way. You seemed like a real person trying to, work through the issues. Whoever drew this line of questions, and it could have been any of you because I didn't know who was going to get them, but I was ready with those questions when I read that de brachio consent. And then there's 3 questions I wanted to ask. And unfortunately, you were the guy that got hammered with them. It wasn't intentional, but it was. Part of what we want to do is pressure test the candidate. We want to push you. We want to ask hard questions. You don't want us to sit here and just say, tell me the facts of this case and what was the law in this one. We really wanted to push. Che got away with it a little bit because he just got on a roll and he was a smooth talker in the beginning. So I didn't have a chance to throw him a curveball, but by the time we were up to you, it's like, okay, here we go. Let's get this guy. It did not impact your scoring in a very significant way, but you did get a little stumped, right, on the questioning. And it may be that a judge asks a question of you that isn't even your issue. It might be the next speaker's issue or something, but you've got to be able to react and take it and either transition or speak to it enough or hand the baton, to co-counsel, because co-counsel is going to address this in greater detail when you hear from him. I thought generally your courtroom demeanor was good. And I thought that your manner of speech and poise were also very good.
Yeah, so let me echo that. I felt, Michael, like you got a little ambushed by the Chief Justice. And so I actually wrote that down. And it took you a little bit of time to gather yourself, but I wrote down, good comeback. You came back well. So good work with that. And it can have, we're seeing it in the Rittenhouse trial right now, right? Where the judge is all over the prosecutor, just ripping him up and ripping him to shreds. So it can happen in real life. So I applaud you for coming back well to that. You had a very good demeanor, very even keel, and that's good. And then I go back to one thing I've already said about everybody, though, is I wrote down, you said it, what I'm attempting to communicate to you is, right? That's a really weak and personal way of saying, well, what's important in justice is this case stands for that, right? Not what I'm attempting to convince you of is the following, right? That's a very mamby-pamby way to get there. So everyone, don't be afraid to just get to your point. As somebody else said that earlier, just, go straight to your point. You don't need a lot of preamble. You don't have to apologize. You don't have to put yourself in the middle of it. Just say, well, as X case says, this is what's important, right? And remember to go there. So don't insert yourself in the argument. But good comeback from being ambushed by the Chief Justice.
Yeah, I think those were, it's always tough to be the first one who really gets the panel really hot. But just a couple of additional comments. So in the same way that I made the comment to Katie to pull back some of her preemptory clash, I would encourage you as a respondent, especially the first speaker for the respondent, clash with what you've heard, because we have on our mind what all of Shay's arguments, and you get the opportunity to have a full rebuttal. Really, your entire argument is a rebuttal in addition to forwarding your party's position. So always make a point to draw contrasts to what the petitioner's arguments are, call them out specifically if they've mischaracterized the law or failed to cite controlling precedent. Those are the kinds of things you can do to really draw a clash and a contrast, and that sticks out in a judge's mind. So easy way to get points. Secondly, the timing for you guys was a little weird. Mike, I know that you rolled over, I think, 5 full minutes over to your partner. So some competitions don't even let you do that. They make you predetermine the number of minutes each speaker is going to have prior to the round starting, and sometimes rollovers can be weird. I know this is kind of a moot point for you guys since you're 3Ls or whatever, 2s and 3Ls, but just consider that making effective use of your time is really important. Other ways to do that besides making your legal arguments, because if you get a cold panel, especially, using your full time can be difficult, but you had plenty to work with from the judges. So I felt like there was ample time to explore the questions and always to revert back to, frankly, your party's policy arguments. Why does standing matter? Standing is one of the most boring, concepts in the law. It's fundamental, but it's not sexy. But your unfortunate position is having to make standing interesting and make an argument out of it that lasts your full, 7.5, 12 minutes or whatever you guys have. So my advice on that for everybody is when you find yourself running out of time, you can always make do with policy, which is really, why should the court care about this? And if you can effectively make that argument or really present that position, irrespective of the law, it's a great way to finish and to segue into a strong conclusion on your legal arguments.
Thank you so much, Justices.
Yeah, you're welcome. And just Michael, when Pete says he thinks the Chief Justice ambushed you, when the judges met in chambers, I got virtual, attitude from everybody. Like, why did you railroad Michael? But it wasn't personal.
I appreciate it. It was fun.
Let's transition to Samuel. Samuel, you're a 3L. Did I hear that?
Yes, that's correct.
Perfect. Okay. There are, I don't know, maybe 5 or 6 lawyers in Houston that have a British accent that I see in commercial cases. And there's a certain charm about them. And depending upon what they say and how they say it, it either sticks or it gets sort of annoying after a few minutes. And I'm just being frank. And with you, it stuck. It wasn't a distraction at all. You're a good speaker, not because of your accent, but because of your command, your poise. And that really applies to everybody here. Again, I felt like you had an excellent statement of the issues. You handled the questions very well. I like in the end, you said the upshot is this. Like, I really like statements where, again, that to me didn't felt rehearsed. It didn't felt like you were reading. It helped me understand that you were taking the cues you were being given and being a bit nimble in answering questions. I felt like, again, high degree of candor from the other end of the screen. It's inevitable with any new law. There are going to be some unfortunate, some outliers, some people may be impacted. I think that's true. It's a very real statement. I didn't feel like it was overly sympathetic from your end. Maybe that was intended. But you're a very gifted speaker. You probably know that by now. Don't let it go to your head. Use it to your advantage. and figure out what else you can do to improve. I think to Carter's point about the time allocation, I think Michael, there were probably a couple of minutes, Samuel, during your presentation that there were these sort of open pauses that maybe Michael could have used some of that time had the team decided, okay, let's have Michael spend a couple of extra minutes, help him develop his arguments, give him a chance to get some rhythm going. Yeah, you did an excellent job.
Thank you very much.
Yeah, obviously, Mr. Hooper, best speaker, congratulations. Always, it feels good to be selected amongst another group of fantastic speakers. So congratulations there. Besides some of the, not to rehash all the comments we already heard, but as Pete had noted earlier, some of the first person language should be avoided, but especially our contention. So our contention is hemming and hawing away from a position you have. Nobody's really contending anything. That's almost like a statement of how facts are to be interpreted. You have a legal position, and it's sometimes if you only want to say our position is, if you're really almost conceding something, because your position is that one thing is true or right. And so you never have to have a contention. The law is. Mm-hmm. So that's how you really can, I think, elevate your persuasiveness. But additionally, and this is a mechanics thing for everybody, on question, you should, if possible, lead first with a yes or a no before you continue and finish the explanation. I think there was a lot of excitement on a question because the panel got cold in everybody's argument at different points, but always take that moment to calmly consider, yes, Your Honor, no, Your Honor, and then give us the explanation, because almost all the questions that were asked were binaries. So you really could give one of the two. And I just noticed that for you, Mr. Hooper. So, but otherwise, no other comments. Conclusions are very important. And Sam, I noticed that you had, I think, the clearest one. And it's always nice when you wrap up right at the end of your time. And it shows that you're paying attention and making effective use there. But congratulations again to you and to everybody else. It was a very fun round.
And so very briefly, it's funny when you have experience in this area and you hear someone with a great accent, and I guess all Americans think that Brits or others have great accents. My immediate reaction, though, is to park that, right? Put it aside and go, don't let that affect your emotion, right? So I want to be really clear about why I believe all three judges were unanimous in the best speaker in the round. And that is that, Sammy, you had a particularly good way of listening to the question, answering the question, and then pivoting back to your argument and or engaging in the conversation between the justice and you, and then getting back to your argument. You know, it's just like, and that reminds me, Judge, this is important because, right, or whatever, right? So transitions, you know, what makes a really great appellate, and Carter's given some really great examples of what you should and shouldn't do. And I kind of feel like what makes a great appellate argument, lawyer, and to some extent a good trial lawyer, because I've done some, but I do much more trial law than appellate, is the ability to be kind of like a talk show host, right? That, well, Judge, thank you for asking me that, right? Or yes, Judge, that's an important point, and here's my response, right? What, you know, you've got to take what you're getting and then parrot it back to them quickly and in a way that you can make your point, right? And so I think Samuel demonstrated that in an exemplar, in an exemplar way during this round, which was he was able to listen, respond, and then continue on as to why is that important, or why is what I'm saying important to you, right? And not get stuck. And you're always going to get stuck sometimes, but that becomes a real art form. If you want to be a trial lawyer, or you want to be an appellate lawyer, or you want to be in a courtroom and talk to a judge, you've got to be able to listen. And that's the other thing that we're talking about, is putting the notes down and not reading, right? I mean, when I was in second and third year at U of H Law School, Byron McCoy our teacher at the time would literally come over to me and others and take our notes away from us and throw them away and say, question that witness. Stop reading your notes, question the witness. And what they teach you is you'll hear it forever and ever and ever. And fantastic trial lawyers will tell you the same thing. You can't go off a script. You can't go off an outline. You can't go, that's why I tell people you can't write questions out, right? Well, when you got to the house, then what happened next, right? If you're tied to that and you get interrupted, you're screwed. So you've got to know where you're going, listen to the answer, and then go with the answer, because often people give you, and judges may give you, an appellate argument, something they're interested in. And if you're so tied to your outline, you may miss what they're asking. So Samuel did a very good job of listening, responding to the question, and then tying it back to the argument. That is incredibly important. And a lot of people don't learn it. A lot of people don't learn it. Things go right over their shoulder. I've seen 5-year, 10-year, 20-year lawyers where things go right over their shoulder. And other people in the courtroom go, oh my God, did you hear that? And the person asking the question, because they're so in their own bubble, didn't hear it. And they're the only one in the courtroom that didn't hear it, and they didn't respond to it or didn't react to it. And that will kill you every time. So that's kind of my last word. Thank you for indulging me.
You guys have any questions of us? Anything specific you may want to ask about? If the judges have a minute or two, I've got a couple of minutes, so I'm happy to stay on if anyone wants to ask anything.
Sure.
I do have a quick question, if it's okay. I was really struck by, first of all, thank you very much for all the feedback. It was super helpful. Just to, so much of the things that at least I say are unconscious. So it's good to know what works and what lands and what doesn't. But I was curious by what was said about, like, if you're a respondent, basically your whole time is a rebuttal in a way. So I was just curious for advice on how much, if you think you spot things that are worthy of rebuttal, how much to kind of throw your existing plan out the window or your existing outline or whatever and focus on those at the expense of, like, the architecture that you had planned to devote your time talking to. Because I've experimented with different approaches throughout this competition, and I'm not sure which one works best, whether to kind of give up on my plan and devote entirely to responding to petitioner, or to kind of mostly stick to my game plan and then just do a little bit at the end.
So I guess I'll just speak briefly to that. Unlike Pete, when I approach either an appellate argument or trial or even a deposition, there are definitely some questions where I will write out each word because I want that buzzword or catchphrase because it ties into a statute, it's part of a jury charge or something like that. But of course, and I'll have an outline, but to his point, you've got to be willing to go where the judge will go or will take you, where the witness will take you. And I think the key, guys, for all of us is preparation. If you're prepared and you know these facts and you know the case law, you can make a game time call. For example, if Katie made a point that you felt like to one of the judge's questions, one of us might be interested in that, take that opportunity, take that cue and said, aha, Justice Patterson asked about that of Katie, let me go back to him, or let me say, just as you brought up, just as Your Honor brought up with Ms. Resnick, and this is why it's important, and then you say it. So I think if you've got, and it will come, the ability to depart from, the comfort of your outline or your bullet points or whatever it is that you're using, that comfort will come and greater confidence with time. It's just that we have this tendency to cling to, our notes, the holding and all that stuff. And we as lawyers, really what we do once we find the right law, it's not to be a robot and just parrot it back to the court. It's to analyze and humanize, make the point, make it persuasively. So I don't have a magic answer for you, except that it will come with time. Maybe these other guys, these other lawyers have some tools of their trade.
I'd like to hear what Carter has to say.
Well, I do have a couple of thoughts. So this is a trick I learned through Moot Court, but I think it certainly applies in appellate advocacy, but also in legal writing. It's the concept of signposting. You can deviate as much as you want to from your argument, and you can, exactly as Matthew suggested, it's always good to follow on a line of questioning that you see the judges are really interested in and throw your hat in the ring, contrast the legal positions, correct a misstatement of the law, etc. But signposting is an important way for you to return to your argument. And part of the way you do that is up front, as you give your introduction. The formality of moot court is helpful. You say, in my time before the court, I'm going to discuss 3 issues, first, second, third, as to my first issue. Then you can jump in and clash. But after you've clashed, you want to returning your honor to the fundamentals of my first issue, which is XYZ, then you can return to your argument. Or if, for example, you get pulled off by a question or you recall something you want to clash with prior to transitioning to your second issue, you signpost. After you finish, you very calmly transition by saying, "And your honors, that brings me to my second point." I think one of the other justices noted that Katie had done that in her argument, and it's very effective. It's a calm transition from one point to the other. But signposting is just dropping that flag, telling the justices, where are you in your argument? And numbering points is very important. It's more helpful than I think saying, and moving on to the issue about validation of this or that, number them to the second point, third point, because good justices are going to have your briefing in front of you first off, but they're also going to have notes. So number your points and transition to them that way. Drop your signpost by number and issue so that they can pick back up. That would be my comment as a way to keep yourself in line, but give yourself the flexibility to deviate.
And give me 20 seconds. I agree wholeheartedly with Carter. And again, my experience is more in trial court than in the appellate court. But you're asking basically, do you take on opposing counsel's position before you go on with your rote outline? And I'll tell you, in trial court, I do it, and I think it's the same in appellate court, which is, but you got to do it in bite-sized chunks, right? You have to say straight out. I mean, I'll have a opposing witness on the stand or something, and the opposing counsel makes this point or whatever, or even in a closing argument or something, they say X, Y, and Z, and you can say, you know what, before I get to X, I'd like to address these 2 issues that Mr. or Mrs. So-and-so brought up. And you better address them quickly, efficiently, and like that, and then go, and now, right, signposting, now back to what I was going to say, right? So if you feel it is compelling, yes, it's important to address something that somebody else has said before it gets lost, because often you will lose it, right? You'll forget or it'll get lost in the argument. So often in a trial courtroom, I will say, with respect to this one point, or with respect to these 2 points, I'd like to address those in 30 seconds, right? Not 5 minutes, in 15 seconds or 30 seconds, and move on to go back to your point.
Thank you very much. That's really helpful.
Yep.
Other
Anybody
questions?
else?
Anybody?
Well, advocates, unfortunately, I have to leave. I have an appointment at 5 o'clock, but I want to thank everybody for giving me the chance to be here. And to my fellow judges, Pete, Matthew, it was a pleasure judging with you. Congratulations again, everyone, and have a good rest of your weekend.
Thank you so much.
Absolutely.
Thank you.
Yeah, great job, everybody. Thank you for the opportunity. Keep going. You're all great.
Yep, absolutely. You all did very well. I can tell you, all of us older guys and gals look back and judge these forums, and we're all blown away. We're like, I wasn't that good when I was that age. So, and I've been doing this for 30 years. So
we'll see the 3 L's. We'll see the 2 L's in the finals next year. Got it?
There you go. Congratulations, everybody.
All right, everybody. Have a great day.
Thank y'all so much.
Thank you. Absolutely.
Thank you
Thank
so
you for the
much.
feedback.
Bye-bye.
Bye-bye.